Welcome back to the Agent of Wealth. This is your host, Marc Bautis. Estate planning is one of those areas that people often put off, but the consequences of poor planning or no planning at all can be devastating for families. Today we're diving into the key problems that arise from poor estate planning, what happens if you pass away without a will, and strategies to protect your assets and your family's future. Joining me for this discussion is Eric Kaplan. Eric is a senior counsel in Greenspoon Marder's International Wealth and Asset Planning Group. With nearly 25 years of experience in estate planning in both domestic and offshore asset protection, he's a widely published author in the field, having contributed to leading industry journals and co-authoring multiple editions of the Asset Protection Planning Guide. Eric, welcome to the show.
Thanks for having me, Mark. Appreciate it.
Yeah, so I know you've been working in the estate planning field for nearly 25 years. What got you interested in this area of law, and what keeps you passionate about it going forward?
Well, nothing specific got me into this area of law. Back in 2000, when I had first started my legal career, my first position as an attorney was at an ambulance chasing law firm where I practiced workers' compensation and Social Security disability. And that job quickly demonstrated to me what type of attorney I did not want to be or how I wanted to be treated by either clients or colleagues. So I responded to a job advertisement in the Denver Post. This was before Indeed or Career Builder or any of the online ways to find a job, but just responded to a newspaper ad at a firm called Engel, Ryman, and Lockwood here in the Denver area. And I got that job based upon two factors. First, one of the associate attorneys at the firm at the time I worked with on a temporary legal job, and he put in a good word for me. And the head of the firm, Barry Engel, is a huge music fan, and in particular a huge Eric Kaplan fan, and he was amused to see my name was similar to his. So he gave me a shot. And although my musical talent certainly isn't in Eric's stratosphere. So meeting new clients, getting to know them, analyzing and creating and subsequently updating their estate plans as needed over the years, and giving them peace of mind is the main factor that keeps me passionate about my work. As most of your listeners in the workforce would likely agree, another important factor to keep oneself passionate about their job is those that you work with. The law firm I work for, Greenspoon Marder, is a great place to work and treats me well. And I would also like to just specifically acknowledge my boss, Edward Brown, with whom I started working with at Engel, Ryman, and Lockwood back in 2001. And except for a 3-year period after the dissolution of Engel, Ryman, and Lockwood, where we both ended up at the different firms for a few years, Ed eventually brought me back home almost 6 years ago, meaning that he's been my boss, colleague, mentor, and friend for 25 years now. He's one of the foremost experts in domestic and offshore asset protection, and also one of the overall the best human beings that I've ever met. His mentorship and friendship motivates me to continually practice at a high level so our client base remains satisfied, and most importantly, so I don't disappoint him.
So it's great to have motivation. All right, so let's start from the top with estate planning. Maybe just start off with the definition of what estate planning is and why is it so important?
Well, estate planning is the process of creating an overall strategy to manage and distribute one's assets, make healthcare decisions, and care for dependents during your lifetime and after your death, ensuring that the individual's wishes are followed, along with the minimization of taxes and other related costs. Now, I'm only licensed to practice in Colorado, so speaking in Colorado terms, an estate plan will usually include a will, sometimes a revocable or an irrevocable trust, a durable general power of attorney, and that's a document where if you become incapacitated or disabled, you appoint an agent to make business and financial decisions on your behalf, a medical power of attorney, so you would appoint an agent to make medical decisions on your behalf, a living will, where you make your wishes known if you're in a persistent vegetative state, otherwise known as a coma, that you do not want any extreme measures to be taken, and you be allowed to pass naturally. There's a HIPAA authorization form, which provides authorization to certain individuals to receive your protected health information from doctors and other medical professionals. And an appointment of guardian for minor children. Oh, I'm sorry.
Yeah, no, I mean, it's definitely a lot involved in it. I guess some or not all those are applicable for everyone, or is it something like a checklist that someone should go through and say, okay, do I have this in place? Do I need this? Or are there certain things that maybe are not applicable for everyone?
Well, a lot of times clients come to me saying, I need a will, and that's all. But I have to get into their goals, their wishes, their desires, their family dynamic, and make recommendations as such. Usually, I recommend all these documents be prepared because you want, um, just from the get go, you want everything protected and your wishes known for every possible contingency that could happen if you become incapacitated, disabled, or God forbid, pass away.
And I'm sure one of the biggest problems is people actually taking that step to talk to you or someone or put these documents together. But what are, aside from that, of someone even just doing it, what are some of the common mistakes that you see when people, oversights or mistakes that people go through when putting their estate plans together?
First and foremost, not implementing any type of estate plan, not a good idea. Everyone needs an estate plan. Um, Failing to update plans to take into account life changing events or changes in the law, not updating assets that have beneficiary designations, such as retirement plans, 401k plans, IRAs, and life insurance policies. Um, Another big item that I see is people pay pay attorneys to create a trust for them, and then they don't fund them during their lifetime. So basically, you have an empty vessel after you pass away, and the whole reason to create a revocable living trust is for to avoid probate. And then if you don't fund it during your lifetime, and you paid an attorney to create this trust, you have to go through the probate process anyway. So it's always important not only to create the trust, but fund it during your lifetime. Um, I find that selecting the wrong individuals to serve as fiduciaries, agents, or personal representatives is a big mistake that needs to be corrected. And also, not properly communicating your goals with your trusted family members. As with everything else in life, communication is key.
All right, so let's actually dive into a couple of those. So the first one, which is not even putting an estate plan together. What happens if you don't have an estate plan?
Uh, well, for purposes of if you become incapacitated or disabled and can't make business or medical decisions on your behalf, someone's going to have to go to court and be appointed as your agent to make those decisions. And that's going to take time and money, and uh, time is probably the most important thing in that point when you're incapacitated. If you pass away without a will, um, you'd have to go through what's called the intestacy statutes in your local jurisdiction, meaning if you pass without a will, everything's going to be distributed according to the statutes, and that might not be what the decedent intended for to have his assets distributed as. That's all. So,
And the other one you mentioned was not updating beneficiary designations on, retirement accounts or things that can have that. Um, and I guess that's when updating for different things like life events that happen. Is that what you were referring to? And basically money or assets going to places where it wasn't intended to go to?
correct. Basically, when you create an estate plan, one of the main things you want to do, in addition to have your will and powers of attorney and all that, you want to make sure all beneficiary designations are properly updated. Assets such as retirement accounts, IRAs, 401ks pass outside of probate. So whoever is listed as the beneficiary by law is going to receive those assets after you pass away. If that's not somebody you want to receive the assets, if your plans change over the years, and you don't properly update it, uh, you risk the chance of somebody receiving assets that you did not at that time want to receive such assets.
And I guess that could be like an ex-spouse if there was a life change with potentially a divorce or something like that.
Right.
I guess in terms of putting all these together, why do you see people struggle with actually taking that step to do it? Is it's just a topic that people don't want to talk about or kind of look at, or are there other reasons that are preventing people from doing it?
Over the years, I've noticed people are afraid to face their own mortality, which is totally understandable. I'm kind of become immune to it over the years, but some people might think, oh, I don't have a will. If I create a will, I'm going to pass away shortly thereafter. It'll be just my luck. And that's not the case. People need to take everything into account and get things done. Um, let's see. Can we stop for 1 second?
Sure.
I forgot the rest of the question. I'm sorry.
No worries. It was just kind of why do people, or what's preventing people from actually, or what are some of the common reasons that are preventing people from actually, and you mentioned, the two of them, that one, they just don't want to face mortality. Two, I guess bad luck kind of, they think if they do it, they're actually going to die after doing it.
And the other one, when we get back on, is that they don't want to spend the money. So.
Okay. Yeah. Just start whenever you want to pick up on the third one. Whenever you want. Go ahead.
And then on next, some people just don't see the need or don't want to spend the money speaking with an attorney to create a proper estate plan, thinking, kind of kicking the can down the road, and they'll worry about it when they have more money or at a different time of their life. But as I said, it should be taken care of as soon as possible and continually updated as your life goes on.
And just to go into a little more detail on what happens if someone doesn't have a will and passes away. You mentioned they go through probate, and they're, without a will, there's one direction, and the statutes determine where the assets would go. And what is it? Each state will have basically like a list, and that says, okay, if this person related, is alive, they would inherit the assets, or if not, go on to the next one and just keep going down until the assets are divvied up.
Oh, correct. Speaking for Colorado only, the assets would go, if the deceased individual had no spouse, it would go to the children. If the deceased had a surviving spouse and no children, or if all the surviving descendants were children of both the deceased and the surviving spouse, it would all go to the spouse. That's fairly straightforward. But then, if you have a surviving spouse and children from a prior relationship, the estate would be divided in a way where the spouse gets a certain portion and the remainder goes to the children. And that might not be what the decedent wanted before, or the spouse and the children might get disproportionate amount of assets and leave bad feelings or lead to arguments. But I mean, that's what the statute says, so it has to be that way. If there's no spouse and no children, then you're getting to more remote heirs. It would go up to the parents of the decedent if they're alive. If there's no parents, then it would go out to the deceased siblings and extended family members. And if an individual dies without a will and without any of these heirs at law, according to the statutes, the property would become that of the state of Colorado to do it as it wishes with.
And we're talking about assets and how they get split. What about a minor child? And if there's no will, where there's no guardian that's named, how does the state determine who would be the guardian of that minor?
Without a will or any appointment document, most likely a guardian ad litem would be appointed on behalf of the minor child's behalf, and proceedings would take place to find a proper guardian for that minor child.
So there's some kind of process where, and what if there's, I guess like kind of conflict, people from multiple sides of the family who are both, trying to be the guardian. I guess at some point the court has to decide who that guardian will be.
Correct. And you're leaving it to chance that it might be somebody that you wouldn't have initially picked, and there's a lot of time and additional costs involved, and who knows what could happen. That's why it's best to make your wishes known and put it down to paper as to who needs to watch your children should you pass away.
Going into a little more detail in terms of like assets and titling and probate, should the goal be to try and avoid or minimize probate whenever possible, in terms of, if in every example or in every instance that I can put a transfer on death or payable on death, I should, even if it is not like a beneficiary designation on an IRA or retirement account, or whether it's a house or some other type of asset. Should that, or is there a reason why it does make sense to put some assets through probate?
Here in Colorado, the probate process can take anywhere from 9 to 12 months minimum, and you're paying an attorney or a law firm to do all this for you. And I'm a proponent of avoiding probate if possible. I prepared my own estate plan to avoid probate as much as possible. So, like you said, TOD or POD on bank accounts. I have a revocable living trust where I transferred my home into it, so it'll avoid probate upon my death, and then my wife's subsequent death, or vice versa. So it allows for a more streamlined process of distributing your estate after you pass away if you're able to avoid probate.
Okay.
Um, what you can do is title your home as joint tenants with you and your wife, as my wife and I initially did, but that upon the first spouse's death, it'll avoid probate. It goes to the surviving spouse, but then it'll have to go through the probate process after the subsequent death of the surviving spouse. So I've just been a proponent of trying to avoid that as much as possible.
Okay, shifting gears to asset protection. Maybe we can talk a little bit about why that's an important part of estate planning, especially for business owners or high net worth people.
Sure. Well, what we practice here in Greenspoon Marder is called integrated estate planning, and that refers to the marrying of conventional estate planning, which, as we discussed, focuses heavily on what happens upon an individual's death, with the lifetime side of the overall estate plan, which focuses heavily on the asset protection component. Now, the asset protection component of an overall estate plan is the process of organizing one's assets in advance to safeguard them against risks to which they otherwise might be subject. To guard against such risks in most situations, assets would be transferred from an unprotected form of ownership, such as direct ownership by an individual, to a different type of ownership or asset using what's known as an asset protection vehicle. Now, sometimes this transfer may involve moving assets from a non-exempt to an exempt form, and other times the transfer may be made to an underlying business entity, such as a limited partnership or a limited liability company. In many cases in our practice, the limited liability company or limited partnership would be combined with a domestic or foreign sited asset protection trust in order to maximize the client's asset protection and estate planning goals. It can't be emphasized enough that asset protection planning must be done in advance of a claim or even a threat of a claim against the client, as asset protection planning generally involves the transfer of assets from a less protected form to a more protected form. All involved parties, including me as the attorney who drafts the plan, must take great care to avoid establishing a plan after the client's assets have been attacked or there is even the threat of attack by a creditor. Protecting assets after there are claims or threats could expose the client and the attorneys to either criminal and or civil liability. All involved parties have to be real cautious and avoid the negative implications that may follow from failing to protect assets in advance of when there are creditors who are entitled to remedies under applicable fraudulent transfer, voidable transaction, or other similar laws. Now, asset protection planning concepts can be applied to any type of assets, whether it's cash, stocks, bonds, managed accounts, business interests, art, antiques, real property, or what have you.
So I guess, and we're talking about asset protection as protection from creditors, lawsuits. Is it like the question I get is how do I protect my assets from taxes? Is that part of it? Is there any strategies with that as well, or are we mainly talking here about protection from creditors or lawsuits?
Mainly from protection, mainly protection from creditors and lawsuits. There are ways to reduce possible estate taxes or income taxes, but no one's going to be able to protect against the federal government. So
How
that
do,
just doesn't happen.
yeah, they will get their money. But I guess kind of on that topic, I know some of the work is offshore structures that are created. How does that work with the federal government in terms of? I'm sure they don't really like assets moving offshore because just as it is harder for a creditor to get to, it's probably harder for them to tax if it's offshore.
Yes, the offshore trusts we create um, are usually domestic for United States federal income tax purposes only. And it's a grantor trust, meaning all income flows through the trust and is reported on the settlor or grantors, the individual who creates the trust, on their individual tax returns each year. So there's no tax avoidance or I'm sorry, there's no tax evasion. Everything's on the up and up and reported every year, even with an offshore trust.
So I'm sure, like with everything, you're creating all these different structures. There's a cost involved. At what asset level or net worth or something does it make sense to actually go through this process versus taking the risk that not going through and taking the risk that a creditor could come after the assets.
Right. Well, let me preface my response by saying you can't transfer all your assets into an offshore trust. You have to leave a certain amount of assets out in your individual name so you don't become insolvent and unable to pay your day-to-day debts and/or creditors. Um, uh, when we're talking to clients, they usually at a minimum have in the $3 to $5 million at a minimum net worth, and we counsel them to transfer a certain amount of assets, maybe 50 or 60%, or it just depends on each individual scenario, a certain amount. And it's what we call a nest egg approach. They put a certain amount of assets offshore, and if all hell breaks loose and they lose everything they have, they still have this protection, these assets protected on the offshore trust that are for their benefit.
But just on that topic, what then happens? Like, can they access those assets that are offshore? And if they bring them back into the U.S., are they exposed to that whatever like you said, all hell breaks loose, or do they somehow then have to leave the country and utilize those assets somewhere else?
Um, the way we create our structures, that generally there are two trustees, a domestic trustee and a foreign trustee. The domestic trustee is usually a trusted individual, a family member, friend, accountant, personal attorney. And there's the offshore trustee. We use generally Cook Islands and Nevis as the jurisdictions for our offshore trusts. Now, we incorporate a clause into our trust where the domestic trustee here in the United States is responsible for administering the trust on a day-to-day basis. So he or she has access to the funds on behalf of the beneficiaries, which may or may not include the individuals who created the trust. So if all hell does break loose and there's a creditor situation, the individuals who created the trust, who have the lawsuit against them, have no access to the trust assets unless the trustees agree that it's a good idea.
Are there certain types of assets that make more sense or less sense to put into an offshore trust? And kind of like a follow up, what about like a retirement account, like an IRA or something like that? Can that go into an offshore trust, or is that something that has to stay domestic?
Well, as a retirement account is a beneficiary designated asset that avoids probate and is already distributed out just to the named beneficiary, we would leave it out of the trust under most circumstances. You can name the trust as the beneficiary, but there's no reason to actually transfer title to that asset into a trust. Um, most of our clients, or a large amount of our clients, they transfer their primary residence into an offshore trust or perhaps an underlying single member LLC, maybe a vacation home. As far as liquid assets like stocks, bonds, cash, we would recommend maybe creating an underlying partnership or limited liability company over which the clients have a little more control as general partner or manager, be able to administer and access those funds as needed on a day-to-day basis.
Do you ever see like, I'm trying to think of like someone who owns a business but maybe has a partner in that business, an unrelated partner in that business? Do you ever see that those types of assets lend themselves to going into an offshore trust, or is it strictly like this is usually kind of a family decision that you're taking assets that you're owning individually or within that family to use?
It's generally assets in the family that we worry about for that type of planning. Um, if there's different types of planning for businesses, that different strategies we can incorporate separately into a different trust. But generally speaking, in the trust that I'm talking about, we just deal with family assets.
And if someone does this, goes through it, puts some of these assets in an offshore trust, and then kind of has buyer's remorse at some point, is any of this able to back out, or is it once it goes into that trust, it's kind of irrevocable and it's in that trust?
The trustees would have the authority under the trust instrument to unwind the trust and redistribute the assets back to the settlors. So it can be unwound. Our legal fees cannot be unwound, though.
Right. All right, going back to estate planning, what's the right amount, like in terms of frequency? How often should someone look at their estate plan, kind of all those documents you went over in the beginning, and determine whether they need to make updates or not?
At a minimum, every few years, you should sit down with a professional and take a look and see if your goals have changed. Um, Individual events that might happen, the birth of a child, a marriage, a divorce, um, a death in the family, those individual type events should trigger something inside of you to want to sit down and make sure your current estate planning goals and wishes and desires are still handled by the way the documents currently read. And if not, you want to get them changed as soon as possible.
All right, Eric, that's all the questions I had for you today. It's been a really insightful conversation. I want to thank you for walking us through the importance of proper estate planning and asset protection. For our listeners who want to learn more or connect with you, where's the best place to find you?
Well, my email address is Eric, ERIC, Kaplan, KAPLAN, at gmlaw.com. And our firm's website is www.gmlaw.com. And I could be reached at either of those places.
Perfect. We'll include that in the resources section of the show notes. Thanks again, Eric, and thank you to everyone who tuned in today.
Thanks for having me. I appreciate it.